it seems like every week there's some new article about a law firm being hacked by bad guys and getting sensitive information of multiple clients. And that's gotten the attention of the legal community.
I'm joined today by James Merklinger. He's the president of the ACC Credentialing Institute. Great to talk to you again, Jim. How are you?
Hey, good, Jason. Thank you.
Yeah, so please tell me about the ACC Data Steward Program.
The Data Steward Program is basically a framework for measuring how well law firms protect the sensitive information of their clients. And it's something that was developed specifically by ACC, the Association of Corporate Counsel, at the request of its board of directors. What we found is that companies were not necessarily measuring how well their law firms were protecting the sensitive information of their clients, and the clients are basically our members. Now, that wasn't because lawyers are incompetent, and certainly not, but it's an area that has been evolving so quickly. The use of technology, and if anything, it's been highlighted through the pandemic because of so many people working virtually. But a lot of sensitive information are sent to law firms intentionally, because the law firms are counseling their clients. There's nothing wrong with that. It's expected, and they should do that. It's just that the bad guys have figured out that's where all the good information is, and they're not looking into or out for the best interests of the companies. They're looking to see how they can benefit from actually stealing this information.
From the law firm perspective, or from the corporate counsel perspective, certainly it's competitive in a sense that they want to have more clients than other clients, and of course they combat in litigation and negotiations with other counsel. However, the idea of sharing and the idea of publishing the fact that they have worked with your program and have achieved a particular threshold or score within your program has to be a competitive advantage for them.
It is, and it's certainly on just the immediate level, publishing a score showing, look, we have taken steps to ensure that we're adequately protecting your information. Now, to be able to demonstrate that in an easy manner, such as here's our score, that's really helpful. At a minimum, it's facilitating discussion. And what I mean is that when we looked into developing this program, we're saying, what are legal departments doing to measure their law firms? We found that the vast majority were not doing anything at all. And that's why we're tasked with developing this program by our board. And doing this, though, helps have a tool by which the in-house counsel, the clients, can measure how the law firms are doing. For the law firms, having a recognized standard helps them demonstrate that they're doing well. It also, from a practical standpoint, helps them reduce the variations in a number of questionnaires they may be answering. We've talked to some law firms that were doing over 50 different types of evaluations a year by different clients, and they're similar but different enough where it still takes a lot of time to answer them. And even some said they had half-time to full-time equivalent working on just responding to questionnaires.
When it comes to legal, I don't know that it's underpinned by specific legislation that says that you must do this around the world. So I think it's a good sign that councils are taking this on as an initiative because it's the right thing to do, not just because they have to.
It really does depend where you are, and obviously with the world, there are many different schemes around this. It seems to be evolving. For example, there's some legislation that went through in the state of New York, where financial institutions, if you were representing a financial institution, I should say, then a law firm need to have a chief information security officer. That's relatively new. In the model rules for professional responsibility issued by the American Bar Association, there is within the model rules a responsibility of lawyers to not only protect the sensitive information about their clients, but also to ensure that the technology they use actually protects them. And two states I know of, Florida and North Carolina, actually now require, as part of their continuing education requirements, that lawyers seek training in technology. When I was coming out of law school, technology was just the computer you typed on. There were no rules around it, or certainly no obligation as a lawyer to seek training. Our training, was directed specifically towards learning more about the law. And now it's a more practical aspect. I think that will continue to expand. But the other part of this, what's interesting is not just from the legal standpoint of what countries may require in the future, but many companies, particularly large companies, have been evaluating their third-party vendors, some for decades. What's interesting is that they sometimes evaluate all vendors except law firms. It seems like every week there's some new article about a law firm being hacked by bad guys and getting sensitive information of multiple clients, and that's gotten the attention of the legal community.
Could you give an example of the types of cyber threats that the program builds a readiness for, the types of the footprint of these attacks, and in the types of mitigations that get put in place?
Yes, well, and again, there's no programs going to prevent bad actors, right, or human error, but it is designed to understand and make sure there are processes and protocols in place, controls in place to protect the sensitive information. And what you're seeing is everything from the bad actors going after the services that law departments are using, or the law firms are using, and hacking information that way. Bad actors have done everything from use ransomware to shut down hospitals, shut down law firms from acting, to taking information which they use for the equivalent of insider trading, stealing information about deals that were going on that were not public, and then trading on a stock exchange. Some of those have been blocked. Others have done that to send out, globally. And people maybe recall the Paradise Papers or the Panama Papers, where information about offshore accounts and many different things from thousands of people, some involved the royal family in England, and that got a lot of attention. That type of information going out. And again, it's not that the corporations are doing something illegal. It's just that it's sensitive information. And for example, they may be contemplating a merger, or maybe it's even a hostile takeover, or it could be litigation. There could be many legitimate reasons for not wanting the information public.
Yeah, and thanks for sharing that, because I recall the first time that you and I talked, you shared a similar story, and like myself, as an information governance professional, of course, I'm aware of ransomware attacks and these types of things. We hear about them all the time. And at the other side, we know the reputational component of some information that you wouldn't want out there that is intended to be confidential, and rightfully should be, gets out, and then you have to deal with whatever consequences, whether they're legal or not. There's reputational consequences. But those ones that are in the middle, these financial market manipulations, and the bad actors profiting through regular channels, through the illegal acquisition of information, for some reason seems especially egregious to me. And it's maybe just because it was fresh information that you provided to me, but it was that layer is something that I hadn't really considered before. And are your clients aware of the vastness of the different impact and the vastness of the cybersecurity threats as they come into it, or is part of this program really educating them on that vastness as well?
Yeah, you hit upon it. It is part of our responsibility as the organization for in-house counsel is to help educate them on that. Some of our members have been in industries that are heavily regulated, and they have probably been concerned with this for decades. But the idea that you need to be looking at your law firms is relatively new. When we surveyed our members, the first time in 2019, we found 70% did not evaluate their law firms. And when we did it again this summer, we found it basically similar numbers. So we've been spending time educating our members about the programs, the controls, as well as law firms. It's a fairly arduous process, not in the sense of the information is difficult to consume, but you have to literally find time, meet, explain, demonstrate what the program is, and then there's always multiple parties involved. And then again, it's something new that in the vast majority of the time they've not previously done. So to implement a new procedure within a corporation is not usually something where they just snap their fingers and do.
I think it will probably come to a surprise to a lot of certainly legal counsel, law firms, that traditionally they will think of IT as a project. We're going to do the cleanup on the shared drive, and then we're going to go, need more security, so we install this software, and the project's then done and we're secure. Where this is truly a program. The behavior that you institute is more important, in my opinion, than the technology that you may end up buying or deploying, and that behavior has to be continuously put in place. Is that surprising to the customers as you work through this?
It's one of those things where when you discuss it, it seems so obvious that they go, of course, but it's also something, I guess the equivalent of saying, why didn't I think of that? So having an independent party, in this case ACC, managing the controls, providing this platform for them to use, frees them up to do really what they're hired for. No one I've interviewed who has responsibility for evaluating the law firms had said that's what they hired me to do. It was just one more task added to the list of things to do that was necessary, but really just ancillary to what their job was. And so they looked at it and said, what a real benefit. And also related to that, some of the companies that had evaluation process share with us that, look, we evaluate our controls every 3 years. And that's a very tedious process and takes up a lot of time. It takes months for them to do. And they said having ACC doing this for us saves us a significant amount of time and money.
I can see how the complacency might have been in place when you're auditing all of your vendors, because there's such an implied confidentiality. It is so well respected. Like when you think of two professions, perhaps the medical profession with your doctor, and certainly with your lawyer, it's unambiguous that when I share something with my lawyer, they're not going to share it with anybody else without my permission. Which is that maybe one of the little hints as to why people are less worried about that information leaking, and then all of a sudden they forget, oh yeah, there's cyber threats, which is not intentional. So could that be part of the complacency?
I think there is that in implicit trust. And again, I can't imagine you would engage a law firm if you didn't trust them, right? I mean, so you have that at this basis, which is a good thing. And at the same time, from, as you mentioned, from a legal perspective, inadvertent disclosure or someone, intentionally hacking in and stealing it, otherwise privileged information would be protected in a court of law. But we're not talking about a court of law. We're talking about real world and the public. And so that may be what lends itself to the, not necessarily complacency, but certainly, the overlooking, evaluating the law firms. And at the same time, technology that has moved so quickly, it wasn't that long ago, but it seems like ages when Target was hacked, and through their vendor, I believe was an air conditioner contractor, right? So Target had all of its safeguards in place, but it didn't have safeguards on this third-party vendor. And that led to a focus on third-party vendors. But nobody was talking about the law firms. And somewhere along the way in the past 10 years, more recent, the past couple of years, the black hats have figured out, why waste time going after one corporation at a time? Let's go after a law firm that has 100 corporations as clients and get the information that way. And it seems to be accelerating. One good thing about the program, it does come up with a score, based on 1 to 100. But what's important is that we're not, as an organization, ACC, telling anyone what the score you should use to engage your outside counsel, because all matters are not equal, right? I mean, a score of 65 might be perfectly acceptable for certain types of matters, and it may be unacceptable for others. You'd want law firms to strive to get as perfect a score as possible, but again, it's ultimately going to come down to the in-house counsel who's engaging the outside counsel to determine what's appropriate. The controls are set, and we evaluate this from time to time, but the process is dynamic. And what I mean by that is that if you don't like your score, but you've identified areas for improvement, it's not a snapshot in time. You don't have to wait another year to get your evaluation. You can work on those things immediately. And we've had several law firms that did the initial evaluation, and prior to sharing their results with their clients, said, you know what, we can do better. Let's look at this, and here is our remediation plan. And they did not release it until they actually took care of those things. So everyone benefits because they were able to use the controls to evaluate how they were. They identified certain deficiencies, or which they felt were deficiencies, and then came up with a plan and fixed them.
Yeah, that's awesome. And I think he kind of tidied up the next leading question is, how does this go? And I think that's, to me, how this goes. Maybe if you could kind of just summarize the main beats, because I think you truly hit them, that you identify what is in place, you mark it against the controls that they should have, you give it a score, and then you give them the mitigation opportunity. Then you continue to evaluate it in the future to make sure that they're leveling up. Obviously it's more nuanced than that, but maybe you could comment about, how does this typically go? How long does it take to get through this before it becomes a program for an organization?
That's a great question, because it does vary greatly. So we've had a couple law firms that had already gone through a full ISO certification, but they felt this program would be great for measuring and demonstrating to their clients their profile, which is interesting. But the other side of that is that the ISO certification is fairly expensive, and so most law firms do not seek that. But the firms that had gone through that process, they were able to go through and answer the questions, by which we have 160 controls, in a matter of 3 to 4 hours. This questionnaire is 40 questions responding to 160 controls, and by which they respond. And some obviously are going to take more effort than others, versus we've talked to people who had, I was shocked, but someone said they had a questionnaire had over 1,000 questions on it. I don't even know how, I don't think I could think of 1,000 questions if my job depended on it. That'd be very difficult.
Yeah, and how do you consume that too? Because you know that the party that you give it to can't possibly invest careful consideration to each of 1,000 questions.
That was a comment that we heard over and over again. Even it sounded even. Some had 400 questions, which still is an amazing amount. The other part to that, related to processing, consuming that information, is that the platform we used to launch this already existed in the sense that it's audit board. It's a compliance portal. It's the #1 ranked in the world, and also not only for the companies using it, but also its security measures. And we intentionally chose a platform that was already functioning and had a great SOC 2 report. That was important for us. So it's not ACC storing this information on our servers, but the platform itself is very dynamic. And again, it's used for measuring compliance, and now we're using it for measuring the security profiles. It has the ability to generate within a dashboard to look at all the law firms that are on the panel for a particular client. So easy use, easy access, and that's important to this function too.
And previously, like when we had talked or met before, you had mentioned pricing. I thought that the pricing of the work that you do was quite reasonable. I'm not going to ask you specifically about the pricing unless you wanted to share. But what I will ask is, what tends to make the program more expensive for people, and what can they do to make the program the most cost effective is for themselves?
Yeah. So within the program, the way it works is that the law firm subscribes and has a license to this, so they can get a single subscription and just pay a very modest. It's currently $1,495 for the license, and they can share that with a single client. Then we have a cap on price where they can pay basically, $10,000 and share it with as many clients as they wish. We're obviously the organization for in-house counsel, and we want to design something that is helpful for the in-house profession, but at the same time recognizing that it's much better to have the collaboration and then something that benefits both the in-house profession as well as the law firms. If it's something that was just forced down on them, they may do it because their clients asking them, but again, in the long run, we're better off with having something that works well for all the parties involved. And it gives, when we initially developed this, we had input from law firms and advisory board, so it wasn't just driven by one side, so to speak, the in-house side.
This is awesome, Jim. And before we started recording here, I thank you, because one thing really interesting is I have a lot of conversations that are about information governance in general. And this is a very targeted specific use case, but it's not niche. This affects all of us. And it is something that's not automatically intuitive. And I feel like the audience is going to think about other areas of their business as well, in addition to their legal counsel, about maybe where they might have information governance. I don't want to say risk, because risk implies it's just insurance or whatever, but opportunities to make their business better. So thanks for joining me today. And please, could you share where people find you and get in touch with the ACC Credentialing Institute?
Yeah, thank you. The website, acc.com, has a link to the accdatasteward.com. Either place you can find. I give you both URLs because acc.com is easy to remember, but certainly the name of the program, accdatasteward.com, is also a direct link.
Awesome. And I like the credibility that it's attached directly to the member organization. It's endorsed by the member organization, and it's a program that ultimately helps everybody. So that's cool. And we'll put the URLs up in front of us right now. So thanks a lot, Jim, and happy holidays. It was really great talking to you.
Yeah, Jason, thank you for taking the time to interview me. I appreciate that. Like I said, we're just trying to get the word out to as many people as possible. And certainly I hope they'll contact me if they have any questions, or feel free to include my email address.
Yeah, we will.
Anything.
Awesome. Right. Take care, Jim.
Great. Thank you. Happy holidays.